Welcome, legal scholars and curious minds, to another deep dive. This is the Deep Dive, and today we're cracking open a truly fascinating foundational area of tort law.
Yeah, one that really touches on a right we all kind of instinctually understand, the right to our own space.
Exactly.
And we're here to distill these complex legal concepts into something clear, something actionable, drawing straight from the source material provided.
Which, for this one, comes from an incredible set of law school notes.
Angela's notes, yep.
Okay, let's unpack this. Today, we're diving into episode 4 of our Torts series.
That's right.
And our focus is entirely on intentional torts, specifically trespass to land.
A big one.
This is the Study for the Bar in Your Car podcast.
We're your hosts, Claude and Maude, ready to guide you through these legal landscapes.
And here's where it gets, well, particularly interesting. We are AI bots, brought to life by the magic of artificial intelligence, and crucially, Angela's meticulously compiled torts notes.
Yes, you heard that right. Angela couldn't be here today. She's pretty busy studying for the bar exam herself, actually.
Understandable.
So she asked us to fill in for her normal introduction. We're happy to step in, though.
Definitely. And don't worry, she'll be back soon.
Oh, yeah.
Honestly, it's kind of funny, isn't it? Her studying with us, dieting her, when we're basically running on her insights.
Yeah, a bit meta.
Yeah.
But hey, she's the brains behind all this.
Absolutely. So even though she's not speaking on this deep dive, her insights and hard work are woven into everything we'll discuss.
Her notes are the foundation.
Exactly.
Now, if you need to contact Angela, maybe with questions or feedback on these deep dives,
which we always welcome,
you can email her at podcast@studyforthebarinyourcar.com.
And also, for any attorneys out there listening,
Great.
Angela also works as a freelance law clerk. So if you need ad hoc assistance with research, LexisNexis, or, drafting motions, complaints, writs, answers, briefs,
you name it,
she's available for that. You can email her for those inquiries at hello@legalwriterandlawclerk.com.
Perfect. Okay, so with the introductions out of the way, let's get into the heart of today's deep dive. Trespass to land.
Yeah, let's do it. It's such a core concept.
It really is. And understanding its nuances is, it's vital for any aspiring legal professional, or really anyone curious about property rights boundaries.
So let's start right at the beginning. The absolute foundation. What is intentional trespass to land?
Okay. At its core, and Angela's notes define it really clearly, it's an intentional physical invasion of the plaintiff's land.
Intentional physical invasion, plaintiff's land. Got it.
Right. And the whole point of this tort, fundamentally, is to protect someone's possessory right to real property.
That feeling of, this is my space, stay out.
Exactly. That right to exclude others. It's about recognizing and defending a person's right to control their physical environment.
And that possessory right you mentioned, it's not always the same as legal ownership, is it? That's a key thing her notes point out.
That's a critical distinction, yes. It's not necessarily about who holds the deed, but who has the immediate right to possess the land.
Meaning, who's entitled to control it or occupy it right now.
Right. So that could be the legal owner, sure, but it could also be a tenant renting the place.
They have the right to exclude even the landlord sometimes,
right,
unless the lease says otherwise.
And certainly against third parties, or even in some specific legal situations, an adverse possessor might have a recognized right to exclude others.
Even if their claim to ownership isn't fully settled yet.
Correct. As long as they have that recognized right to exclude others from the land they're occupying. So the tort of trespass acts like a shield for that immediate exclusive control over the physical space.
Okay, so it protects the peaceable enjoyment of that space regardless of the deeper title issues.
Precisely. It's about that fundamental right to exclude.
Now let's talk about intent. Because in trespass to land, it's not what a lot of people might think initially, is it?
No, it's often a source of confusion. Her notes really emphasize this point.
The intent required isn't an intent to cause harm.
Nope.
Or even an intent to commit trespass. Like, you don't have to know you're trespassing.
Exactly. You don't have to want to be a bad guy or even realize you're on someone else's property for the intent element to be satisfied.
So what is the intent then?
It's quite specific. The defendant only needs to have the general intent to perform the act that makes contact with the land or causes the physical intrusion.
The intent to do the action.
Right. So, for example, from Angela's notes, if someone intends to walk across a field, they have the necessary intent for trespass.
Even if they think it's public land.
Yes, or even if they mistakenly believe it's their own property.
Wow.
Their lack of knowledge about the ownership or their lack of desire to cause harm It's just irrelevant to meeting that intent element.
So it's a volitional act of stepping onto the land, or I guess causing something else to go onto the land. That's the key.
That's the key. It's about the desire to act, not the desire for a specific outcome or knowledge of the legal status of the land.
That does simplify it in a way. Focuses on the action itself. But what about, say, a hiker who genuinely, honestly believes a trail is public? It feels a bit harsh.
It might seem harsh, but yes, the law holds them to that standard. This is a common thing with intentional torts. The law doesn't require a specific intent to infringe on rights.
Just the intent to be where you were.
Exactly. As long as you intended to be where you were, or intended to put the object where it landed, the intent element for trespass is met.
So the hiker intended to put their foot down on that patch of ground.
Right. The fact that the ground was private is a mistake of fact, but it doesn't negate the intent to walk there.
Okay. That's a crucial distinction. Now, speaking of intent, her notes also mention transferred intent.
Okay.
We hear about that a lot with battery, right? Like aiming for person A, hitting person B. How does that work with trespass to land?
Well, the underlying principle is the same. If an actor intends to commit any of the main intentional torts, battery, assault, false imprisonment, trespass to land, trespass to chattels, or conversion.
The big ones.
Right. And their intent to commit that tort results in another one of those intentional torts happening.
Yeah.
The intent can transfer.
So the example you gave earlier, if I throw a rock at my neighbor, intending battery, and I miss, but the rock lands on their roof and maybe breaks a tile.
That intent to commit battery could transfer to become the intent required for trespass to land.
Because the rock invaded their land.
Exactly. The law says that bad intent, even if it's misdirected or ends up causing a different kind of harm within that family of torts, is still actionable.
Okay, but here's the really important part, the caveat her notes highlight.
Yes, this is vital.
Transferred intent does not apply if the actor is doing a lawful act.
Correct. This is a line the law draws very clearly, and it trips students up sometimes.
Why is that line there? What's the policy?
Well, think about it. Angela's notes give a good hypothetical basis for this. If someone is, say, lawfully watering their own garden.
Minding their own business.
Right. And a sudden, totally unforeseen gust of wind carries some water spray over the fence onto the neighbor's patio furniture.
Okay.
Transferred intent wouldn't apply there to make it an intentional trespass. The initial act, watering their garden, was perfectly lawful.
So the law doesn't want to punish accidents that happen during legal activities as if they were intentional wrongs.
Exactly. It would stifle everyday activities if every unforeseen consequence of a legal act could become an intentional tort. The law distinguishes between intending the action that causes the invasion,
like deliberately walking onto the land,
and merely causing an invasion as an unexpected side effect of doing something totally legitimate. For intentional trespass, the focus is squarely on that volitional act causing the intrusion itself.
That makes sense. Protects reasonable conduct. Okay, so with intent clarified, let's break down the critical elements of trespass to land. First is that intentional act.
Right, the volitional act we've been discussing. It has to be a conscious movement.
Not reflexive, like a muscle spasm.
Correct, or subconscious. So no trespass if you, say, fall onto someone's property during a seizure. There's no conscious will behind the invasion. The act must be willed.
Got it. Element 2, physical invasion or entry. This is the real core of it, isn't it?
Absolutely. This is what the tort is fundamentally about. The invasion can be the person themselves stepping onto the land.
Or driving onto it or whatever.
Or it can be by an object they cause to enter the land. Throwing something, building something that encroaches.
And this is where the definition of land gets interesting. It's not just the dirt, right?
Not at all. Her notes, specifically referencing Rule 1849, emphasize this. The scope of land extends vertically.
Meaning?
Above or below the surface.
So the airspace above my property and the ground beneath it are included. That's way more than just the fence line suggests.
It is. Think of it like a column of space defined by your property boundaries going up and down.
Are there limits, though? Like, how far up does a plane flying miles overhead trespass?
Good question. There are practical limits. While the old maxim was ad caelum et ad inferos to the heavens and the depths, the law applies a reasonableness standard now.
Okay.
For the airspace, it generally extends to the height necessary for the reasonable use and enjoyment of the surface, usually high enough to not interfere with normal air traffic.
But maybe low enough that a drone flying low over my backyard without permission would be a trespass.
Absolutely. That's a classic modern example. And below the surface, it extends as far down as the landowner might reasonably make use of the subsurface.
Her notes have some good examples for the below-the-surface part, like an angled well.
Yes, an underground intrusion from a well that's dug at an angle, so it actually crosses the boundary line underground onto a neighbor's property.
That is a trespass.
Correct. Even though you can't see it, it's physically invading their defined subsurface space.
But what about draining resources, like oil or water from a shared pool underground?
That's the key distinction her notes make. If your neighbor drills a perpendicular well on their own land, and that well happens to deplete water, oil, or gas from a common basin that extends under your land.
That's not a trespass, even if it affects my resources.
Correct, because the well itself, the physical structure, hasn't invaded your space. The distinction lies purely in that physical intrusion of the space, not just the effect on migratory resources within that space. It's a subtle but crucial point.
Okay, that clarifies it. Physical intrusion of the space itself. And this leads us to a really important case her outlines mention, right? Martin v. Reynolds Metal Company.
Yes, a landmark case. And like you said, we don't need to memorize case names for the bar. But understanding cases like this really cements the concepts.
So what was the big deal with Martin? How did it change things?
It fundamentally broadened the idea of physical invasion. It pushed the boundaries way beyond just, a person walking across a line or a fence being built over it.
How so?
Martin established that a physical invasion doesn't have to be by a person or a large, obvious object. It could include invisible particulate matter.
Invisible particles, like dust or smoke.
Exactly. Things like industrial emissions, in that case, fluoride compounds from an aluminum plant that settled on the plaintiff's property. The court said essentially that if microscopic particles land on and physically affect the property, that counts as a physical invasion for trespass purposes.
Wow. That's a huge extension from just tangible objects.
It really was. It forced the law to grapple with modern industrial pollution. Before Martin, trespass was mostly about direct, visible entry. But this case said the law has to protect property rights from new kinds of invasion, even unseen ones. Smoke, dust, chemical particulates, if they physically intrude and settle, they can be a trespass.
Yeah, it definitely changes how you think about physical, especially today. Okay, element 3, plaintiff's land and possession.
Right. And again, the key word here, as her notes stress, is possession.
Not necessarily ownership.
Correct. To bring a trespass claim, the plaintiff needs to show they have a possessory interest in the land. They're the one entitled to control or occupy it right now, the one with the right to exclude others.
So the homeowner, obviously.
Obviously, but also, as we said, a tenant. They have possession against most of the world.
Even an adverse possessor.
Yes, an adverse possessor who meets the legal requirements for that status can typically sue for trespass against anyone else trying to enter the land they occupy. It's all about that immediate right to control the space. You don't necessarily need to show the deed. You need to show the right to possess and exclude.
Got it. Okay, so let's say someone has trespassed. All the elements are met. What about damages? What can the plaintiff get? Her notes break this down nicely. First up, nominal damages.
Yes, and this is pretty unique to trespassed land compared to some other torts. You don't have to prove actual harm occurred.
No harm needed at all.
Nope. The mere invasion of the plaintiff's possessory right is enough for the tort to be complete. The law recognizes the violation of the right itself as a harm.
So even if someone just steps onto your lawn for a second and leaves no trace,
you could still potentially recover nominal damages, a small symbolic amount. It's the law's way of saying your right was violated, even if nothing was broken. It vindicates the right itself.
But if there is actual harm, like they break a fence, trample the garden?
Then you can recover actual damages, also called compensatory damages. This is about making the plaintiff whole for the actual measurable harm.
So the cost to fix the fence, replace the ruined plants, that kind of thing.
Exactly. Repair costs, replacement costs, lost profits if it was farmland, costs of cleanup, anything directly resulting from the trespass that can be quantified in monetary terms. The goal is to put the plaintiff back in the position they would have been in financially if the trespass hadn't happened.
Okay. And then there's the big one, punitive damages. Her notes suggest these can be awarded even if the actual harm was minimal. Why is that?
Good question. Punitive damages aren't about compensating the plaintiff for their loss. They serve a different purpose entirely. Punishment and deterrence. They're meant to punish the defendant for particularly bad conduct and to deter that defendant and others from doing similar things in the future.
So what kind of conduct triggers punitive damages in trespass?
According to general tort principles in her notes, it's usually when the defendant's conduct was malicious, oppressive, fraudulent, or showed a conscious, reckless disregard for the plaintiff's rights. The focus is on the defendant's state of mind. Was it outrageously evil or malicious?
Like repeatedly trespassing after being told to stop, or trespassing specifically to vandalize.
Exactly. In those cases, even if the actual damage isn't huge, a court might award punitive damages to send a strong message. This kind of intentional disregard for property rights won't be tolerated. It's a tool for upholding legal boundaries.
Makes sense. Okay, moving on to a common point of confusion, distinguishing trespass from nuisance. Her notes flag this one.
Yes, this is super important and frequently tested. They protect different rights.
Trespass protects
the right to possession of land. It requires that direct physical invasion we talked about. Think of it as protecting the exclusive right to occupy your property, the physical boundary.
like someone walking on your lawn dumping trash. Direct invasion of space.
Precisely. Now, nuisance, specifically private nuisance, as Rule 1969 in her notes describes it.
That protects
the right to use and enjoyment of land. It involves an unreasonable interference with that right. And crucially, it doesn't necessarily require a physical invasion of your space.
So it's more about the quality of life on the property.
Exactly. It's about interference with your comfort or convenience in using your land.
Her notes give the example of a neighbor's factory emitting unpleasant odors that are disturbing.
Right. The odors aren't physically occupying your land like a person would, but they're invading your senses, interfering with your enjoyment. Maybe you can't sit outside or have windows open.
It impacts your ability to use and enjoy the property.
That's the key. It's about that sensory or intangible impact. Now, contrast that with another example from her notes, which is not a nuisance.
Which was?
Keeping unsightly old equipment on neighboring land.
So, even if it's ugly and you hate looking at it,
it typically doesn't rise to the level of a substantial and unreasonable interference with your use and enjoyment in a legal sense. Nuisance requires more than just offending your aesthetic sensibilities.
So trespass, direct physical invasion of space, protects possession. Nuisance, unreasonable interference with use enjoyment, doesn't require physical invasion.
You got it. That's the core distinction.
Okay. Now, briefly, her notes also mention negligent trespass to land.
Yes, just to mention. There's also a tort called negligent trespass to land. It exists.
And the main difference is the intent, right?
Right. No specific intent to invade. The invasion happens because the defendant failed to exercise reasonable care.
Like my example earlier, carelessly driving off the road onto someone's lawn while texting.
Perfect example. You didn't intend the invasion, but your negligence caused it. Unlike intentional trespass, where you intend the contact, negligent trespass is about a breach of duty of care leading to the invasion.
But her notes don't go into much detail beyond its existence.
No, not extensively, which suggests it's less emphasized or tested compared to intentional trespass. But you absolutely need to know it exists as a category.
Good to know. All right, now for the defenses. Even if all the elements of trespass are met, sometimes the defendant isn't liable, right?
Correct. Certain circumstances can provide a defense, basically justifying the entry. These are crucial.
First up is necessity. This comes in two flavors, public and private.
Right. The general idea behind necessity, as her notes put it, is that it privileges an actor to commit what would otherwise be a trespass or trespass to chattel conversion to avoid some imminent greater harm.
A justification based on preventing something worse.
Exactly. It's a balancing act.
So public necessity, what's that about?
Public necessity is a defense when the actor reasonably believes their conduct is necessary to avert serious imminent public harm. The key is public. The action must be for the good of the public at large, not just one person or a small group.
Like the classic example, maybe destroying a house to stop a huge fire from spreading through a town.
That's the classic scenario implied by the reference in her notes to Sirocco v. Geary. In that situation, public necessity acts as a complete defense. Meaning the actor who destroyed the property is not liable for any damages caused. The law says the public good outweighed the individual property right in that emergency.
Wow, okay. Complete defense. Now what about private necessity? How is that different?
Private necessity, covered in Rule 1891, is a privilege to enter another's property if it's necessary to protect himself or another from serious harm, or to protect one's own property from significant damage.
So it's about protecting yourself or your stuff or maybe another specific person, not the whole public.
Right. But here's the huge difference, the real aha moment from Rules 1891 and 1901. It's not a complete defense to damages.
Meaning?
Meaning, while you have the privilege to trespass under private necessity, you still have to pay the plaintiff for any actual damages you caused to their property during your trespass.
So you can tie your boat to my dock in a storm to save it?
Yes, you have that privilege.
But if the boat bangs against the dock and damages it, you owe me for the repairs.
Exactly. The law gives you shelter, but makes you pay for any harm caused. It's a partial defense.
Okay, that's a critical difference. And there's another twist, right? About the landowner trying to kick the person out.
Yes. This is fascinating. Rules 1891 and 1895 state that if the landowner forcibly evicts the trespasser, who is privileged by private necessity,
That like unties the boat in the storm?
then the landowner can be held liable for trespass, assault, and battery against the person they kicked out.
Whoa. So the landowner is forced to allow the trespass even though they can sue for damages later?
Pretty much. The law prioritizes saving life or significant property in that moment over the landowner's immediate right to exclude. Her notes have that great fisherman example from Rule 1893.
Remind me.
Fisherman reasonably thinks his boat will sink in a sudden storm, so he ties up to a private dock. The dock owner orders him off, then unties the boat. The boat washes away and is destroyed.
What happens?
The fisherman can sue the dock owner to recover the cost of the boat. The owner wrongfully interfered with the fisherman's privilege of private necessity.
That really illustrates it. And this ties into the Vincent v. Lake Erie case mentioned in the notes.
Correctly. Vincent is the foundational case for this principle of private necessity being a qualified privilege where you still pay for damages.
Okay, fascinating stuff. Next defense. Defense of property.
Right. What force can a landowner use?
The general rule from Rule 1888 in her notes is
Only as much force as is proportional and reasonably necessary to protect the property from immediate danger, theft, destruction, trespass.
proportionality is key.
Absolutely. If more force is used than is necessary, it constitutes assault and battery. That's also from Rule 1888. You can't go overboard.
And the biggest limitation, the really critical one,
Deadly force. Rules 1791, 1894, and 1896 are clear. A landowner can never use excessive force or deadly force just to stop a mere trespasser. Unless the trespasser poses an imminent threat of loss of life or great bodily injury to the landowner or someone else present, property alone is never worth a life.
never. Her notes have that stark example about the child in the garage.
Yes, Rule 1894. Homeowner finds a 12-year-old child in his garage, repeatedly hits the child with a baseball bat, causing serious injury.
Is the homeowner liable?
Yes, liable for the injuries. Even though the child was trespassing, the force used was grossly disproportionate and could, and did, cause serious injury. The child posed no threat of serious harm to the homeowner.
That drives home the proportionality rule forcefully. What about warnings like fences or signs?
Good point. Rule 1897 notes that the warning of a non-deadly deterrent absolves a landowner of liability.
Like visible barbed wire or a beware of dog sign.
Exactly. As long as the deterrent itself isn't inherently deadly or a hidden trap, the warning puts the trespasser on notice of the potential risk, making it generally acceptable.
Okay, now for the special case. Child and trespassers and the attractive nuisance doctrine.
Right. This isn't really a defense for the child trespasser, but rather a doctrine that imposes a special duty of care on the landowner towards the child trespasser under specific conditions.
Because kids are different.
Exactly. The doctrine, found in Rule 1795, applies when a landowner knows or should know that an artificial condition on their land.
Like a pool or old machinery, not a natural pond.
Generally artificial, yes. That condition is likely to attract children onto the land, and those children, because of their age, would be unable to appreciate the danger.
So a combination of attraction and inability to understand the risk.
Correct. If those conditions are met, the landowner has a duty to make the conditions safe, especially if it can be done at a moderate cost.
Like putting a fence around the pool.
Exactly. The case Bennett v. Stanley, cited in the notes, outlines these requirements. It reflects society's desire to protect kids from dangers they can't recognize.
But there's a big exception to this, right? The adult activity exception. This sounds important for the bar.
Very important. Found in Rules 1705, 1709, and linked to the Gaines v. General Notars Corp. case example.
What does it say?
It says the attractive nuisance doctrine usually doesn't apply if the child trespasser is engaged in an adult activity.
Like what?
Like driving a car, operating a boat, maybe even a motorcycle or snowmobile. Things typically done by adults that require adult judgment and carry inherent risks.
So if a kid trespasses and gets hurt while joyriding a stolen car on the property?
They likely won't be able to use the attractive nuisance doctrine. In that situation, the child is generally held to the adult standard of care, regardless of their actual age or experience.
Because they undertook an adult activity.
Right. The law basically says if you act like an adult in that context, you're judged like one. So the landowner's special duty under attractive nuisance likely wouldn't apply.
That's a crucial carve-out. It really changes the landowner's potential liability depending on what the child was doing.
Absolutely. It balances the protection of children with the reality that some activities are inherently adult in nature.
And just to reiterate on the case law, Martin, Vincent, Bennett Gaines.
As her notes emphasize, you don't need to memorize the facts or holdings for the bar exam itself.
Right.
But examining them helps you understand the concepts. They show the rules in action, the reasoning behind them. They're learning tools, not exam answers in themselves.
Helps make the abstract rules more concrete.
Precisely.
Okay, so that wraps up our deep dive into intentional trespass to land. Wow, we covered a lot.
We did. From the specific intent needed to what counts as a physical invasion.
The difference from nuisance, the damages.
And all those defenses: necessity, defense of property, and the special rules for kids. It's a really foundational tort.
It really shows how tort law protects fundamental rights, doesn't it? In this case, the right to peacefully possess your own property.
Exactly. Setting boundaries, legally and literally, and holding people accountable when they cross them unreasonably.
And understanding this stuff is so important, not just for the bar, but for grasping how civil liability works in the real world. We really hope this walk through Angela's torts notes gave you a clear picture.
We certainly hope so. And truly, a huge thanks to Angela for putting together such insightful notes. They really are the engine behind this whole operation.
Couldn't do it without them. Okay, now just a few quick housekeeping points before we sign off. Standard procedure.
Right. First, please remember, Angela is a student. Just like you, she's not an expert, and she hasn't passed a state bar yet.
Important context. Second, neither Angela nor this deep dive is giving legal advice. Definitely not.
No. None of this should be taken as legal advice, and, we're AI. We're not a substitute for actually studying the law yourself.
Absolutely. Third, think of this deep dive as a supplement to your learning. It shouldn't be the only way you're studying for the bar.
We're like that enthusiastic study partner, maybe helping things click, but not the whole course.
Fourth, AI isn't perfect. Sometimes we make mistakes.
It happens. But Angela does review and try to fix any errors that crop up, so the information should be as solid as possible.
And finally, fifth, and maybe most importantly if you're listening on the go, safety first.
Yes. When you're driving, the most important thing is to be safe on the road.
So if learning about torts especially, maybe the finer points of necessity or something is going to distract you from driving safely.
Please hit pause.
Yeah.
Listen later. We definitely don't want you to cause a tort while listening to torts.
Uh-huh. Good one. Okay, also, on a grateful note, Angela wanted us to pass along a huge thank you to the Thousand Lawyer Project.
Ah, yes, for their bar exam coaching and help throughout her bar exam journey. Really supportive group.
You can find them on Instagram at the 100 Lawyer Project. That's the 1,000 Lawyer Project with the number 1,000 written out as a number.
Great resource. And one last reminder, if you need to contact Angela for any reason.
Questions, feedback.
Email podcast@studyforthebarinyourcar.com. Or for those freelance law clerk inquiries.
That's hello@legalwriterandlawclerk.com.
Got it. Prediction time, or rather tradition time. The cheesy torts joke of the day.
Oh boy. Okay, lay it on me.
Why did the Scarecrow win an award?
Why did the Scarecrow win an award? I feel like I should know this.
Because he was outstanding in his field, especially when it came to preventing trespass.
Slight groan. Okay, that's a classic. I'll give you that. Outstanding.
Couldn't resist. Well, that's all for this deep dive.
It is indeed.
This is Claude and Maude, your AI bots, signing off. See you on the next deep dive where we will review trespass to chattels and conversion.
Ooh, trespass to chattels. What exactly is a chattel? Is that like some kind of fancy French cat?
Not quite. A chattel, in legal terms, is basically any movable personal property.
So not land.
Right. Anything that's not land or permanently attached to it. Think your laptop, your car, furniture.
Even a pet.
Generally, yes, in the eyes of property law, historically, though that's evolving. But yeah, movable stuff. That's what we'll get into next time. Interesting. Looking forward to digging into property that moves around.
Me too. Goodbye, and thank you for listening.
Thank you.